landline. In today's Legal on 4, love and legal issues. Unlike married couples, people living together, no matter how long they've lived together or how significant the relationship is, need to do some planning to give an unmarried significant other some legal rights. Our legal contributor, Craig Wisdom, joins us now. And yeah, it's kind of built into your marriage document that the other person survives you.
Exactly. It's still important to plan if you're a married couple, if you have children, but it becomes even more critical.
And why is it so critical?
Because, for instance, in terms of planning, in terms of things like who gets property at your death, or who helps you make decisions if you become incapacitated, if you have documents that establish that, great. If you don't, the law has to guess what people are going to have those type of rights. And when you die, and if you have to figure out who gets your stuff, if you don't have a will, we have what we call intestate law. You don't have a will. And the law has to guess who you'd want to get your property. And it's reasonable. You know, if you had to make a list, it says first it goes to your spouse, and then it goes to your kids or your grandkids, and if you don't have them, it goes to your family. But nowhere in there are kind of amorphous concepts like someone you've lived with a long time. No matter how deeply you're involved, you could be married 20, 30, 40 years, it could be the closest, it could be the only relationship in your life. It doesn't matter. You're not in those lists of people that have rights to take under the intestate law.
Does Arizona have common law?
They do not, no. So it doesn't even matter, you know, if common law marriage is the idea that you're not officially married,
been together so long.
You've been married, you've been together so long, and you've acted like you've married, and you've told people you're married. And even in states that have it, it's a very stringent requirement. Arizona does not recognize that. So there's no matter how deep it is, unless you know you're married, you don't have any rights. The good news is it's easy to get around this. Do some planning, put a will in place, have a power of attorney naming this person that's in your life. So it doesn't take much to take care of this issue, but it's so critical to take care of.
And so really all it is establishing in a will what you want to go to who, right?
Exactly. You know, if you're married, if you're together 20 years but not married, and one person has, you know, their closest family might be like a niece and nephew or a cousin or something like that. If they don't have a will and they die suddenly, this person they've shared their life with doesn't get anything. It doesn't matter how much they can prove that's not what the person wanted. Doesn't matter how, you know, they can prove that they hated their family, they didn't have anything to do with them. Their family's going to get everything. Now, on the other hand, if they just did even a simple will that says, look, I leave everything to the partner that I share my life with, that's going to take care of them, and that's the end of the story.
Is there any time frame with these wills? Like, for example, if you get married and then a month later your husband dies, can that be questioned?
There's a lot of things you can argue about, but there's nothing automatic in the law like that. If you do a will that says who gets it, that's going to be valid unless you didn't know what you were doing or someone coerced you into it. If you got married a short time ago, it doesn't really matter. You're a spouse. It doesn't matter really whether you were a spouse for one day or 50 years.
And some people just really like doing it yourself. Can you do something like this over the internet or
you know, you can. Like a lot of things, it's probably better than nothing, but not as good as going through an attorney and making sure you understand the right questions and that everything's appropriately covered.
And how much something like that would cost?
Basic wills probably are going to cost people about $400, $500, $600 depending on who they see. You know, they can do it themselves. They can handwrite something. Again,
is that valid?
As long as it's all in your handwriting and dated and signed, it is valid. Now, a lot of times you might miss things doing those ways. So it's possible it could cover everything, but you just don't quite have that assurances that you do when you go through a lawyer. But regardless, you've got to think about this. Take the time. Once you get it done, you don't really have to think about it anymore.
It's done unless you want to change it.
Exactly.
Okay. Craig, thank you so much.